I opened the HOA envelope expecting the usual nonsense, some vague warning about my lawn or a reminder about trash bins. Instead, the notice inside stopped me cold. Violation, unauthorized shadow. Fine, $1,000. I actually reread it 3 times, convinced I was missing a page. A shadow. No measurements. No photo. Just a bolded line claiming my home was casting a non-compliant shadow onto a common aesthetic zone. At first, I laughed. I mean, how do you even control a shadow? Tear down the sun. Rotate the earth. But the laughter faded fast when I reached the bottom of the page. Failure to pay within 10 days will result in escalating fines and possible legal action. They were serious. Dead serious. Somewhere, an HOA board had voted and agreed that sunlight falling at the wrong angle was my responsibility. I called the HOA office immediately. After 15 minutes on hold, the board secretary answered with the tone of someone who'd been waiting all day to feel important. She explained that my home addition, approved years ago, was now creating an extended shadow during late afternoon hours. Apparently, this shadow made a patch of grass look visually inconsistent compared to neighboring lawns. That inconsistency, she said, violated community standards. I asked the obvious question, how am I supposed to fix a shadow? Her answer was chillingly casual. You can explore mitigation options. Landscaping. Structural changes. Or you can just pay the fine. Structural changes. To my house. Because of sunlight. When I pushed back, she warned me not to argue with the board, and reminded me that continued resistance could lead to liens. That's when I knew this wasn't about shadows. It was about control. Over the next few days, more letters arrived. One mentioned daily penalties. Another hinted at court enforcement. Neighbors started whispering. Apparently the board president had been bragging about finally teaching me a lesson. All because my house dared to exist between the sun and the lawn. So I did the one thing they clearly didn't expect. I didn't pay. I gathered documents. Old approvals. City permits. HOA bylaws. And when the final notice arrived, pay or appear in court, I smiled. Because if they wanted a judge to rule on a shadow, I was more than happy to let them explain it, out loud. 2 days after I refused to pay, the HOA escalated fast. This time, the letter didn't come from the board, it came from their attorney. Thick paper. Formal tone. Lots of bold words meant to scare people who don't know their rights. According to them, the $1,000 fine was now fully enforceable, and my refusal to comply showed a pattern of defiance. They added $250 in administrative fees, just for sending the letter, bringing my total to $1,250, for a shadow that still appeared every afternoon like clockwork. The attorney's letter claimed the HOA had expert determination, proving my home caused a material loss of visual harmony. No expert name. No report. No photos. Just a sentence saying the board had determined it, which apparently was supposed to be enough. The funniest part, they demanded I submit a shadow mitigation plan within 14 days. I stared at that line for a long time, wondering if they expected diagrams of the sun or a construction proposal to block daylight itself. Then came the threats. Liens. Collections. Court costs. They warned that if the matter went to court, I'd be responsible for their legal fees too. It was classic HOA intimidation. Flood the homeowner with scary words and hope they panic and pay. I could almost hear the board congratulating themselves, convinced I'd fold once a lawyer got involved. But I didn't panic. I did the opposite. I pulled my property file and found the original architectural approval from years ago, signed by the HOA itself. I printed city permits showing the structure was fully compliant. Then I read the bylaws carefully, line by line. There it was, in black and white. Fines required objective standards, documented violations, and photographic evidence. Shadows weren't mentioned anywhere. Not once. That's when I sent my response. Polite. Deadly. I asked for the expert report, the photographic proof, the exact bylaw section defining a shadow violation, and the vote record approving the fine. I also reminded them, politely, that filing a lien without lawful authority could expose the board to personal liability. I hit send and waited. The reply came quicker than expected. Court summons attached. No evidence. No explanations. Just a hearing date circled in red, as if that alone would intimidate me. And that's when I realized something important. The HOA wasn't confident. They were desperate. Because people who have real proof don't rush to court hoping a judge won't ask questions. And unfortunately for them, judges ask a lot of questions. Smiling face with horns. Court day arrived, and the HOA showed up like they were walking into a victory parade. The board president sat front and center, arms crossed, smirking like this was a formality. Their attorney came in loaded with folders, rolling a suitcase behind him as if he'd brought an entire case library. You could tell they expected me to panic, to stumble over words, maybe even to settle before the judge took the bench. Instead, I sat quietly with a single binder and watched them over-prepare for a fight they didn't understand. When the case was called, the HOA's lawyer launched into his opening statement with full confidence. He talked about community standards, visual harmony, and my so-called refusal to cooperate. He emphasized the $1,000 fine like it was a serious enforcement action, not something based on sunlight. The judge listened without interrupting, flipping slowly through the file, while the lawyer spoke faster and louder, mistaking silence for agreement. Then it was my turn. I didn't argue. I didn't raise my voice. I simply handed the judge my documents, city permits, HOA architectural approvals, and a highlighted copy of the bylaws. I explained that the structure had been approved years earlier by the same HOA now fining me. I also pointed out that the violation notice contained no photos, no measurements, and no written standard defining what a shadow violation even was. The courtroom got very quiet. That's when the judge leaned forward. He asked the HOA attorney if they had any photographic evidence of the alleged violation. The lawyer hesitated. Then he said they did not, because shadows are naturally transient. The judge raised an eyebrow. He then asked for the expert report referenced in the demand letter. Another pause. The attorney admitted there was no formal report, just a board determination. The judge looked down at the paperwork again, slowly exhaled, and turned his gaze back to the HOA table. The smirk on the board president's face was gone now, replaced by something closer to concern. Because the confidence they walked in with had just evaporated. And the judge still hadn't asked the question that would end everything. The judge sat back in his chair and tapped his pen against the desk, eyes moving from the HOA attorney to the board president and back again. The courtroom was silent in that heavy, uncomfortable way where everyone knows something bad is coming. Then the judge finally spoke, calmly, almost casually. Can you show me the section of the bylaws that defines a shadow as a violation? The HOA attorney froze. Not dramatically, just enough for everyone to notice. He flipped through his binder, pages rustling louder than they should have in such a quiet room. He cleared his throat and said the violation fell under general aesthetic standards. The judge nodded once, then asked him to read the specific language out loud. What followed was a painful pause. There was no language. Nothing about shadows. Nothing about sunlight. Nothing even close. The judge leaned forward. So, he said slowly, this fine is based on an interpretation created by the board, not a written rule approved by the members? The attorney tried to recover, arguing that boards must have discretion to enforce harmony. That's when the judge cut him off. He explained that discretion doesn't replace written standards, especially when money and property rights are involved. The board president shifted in his seat. Hard. Then came the moment no one expected. The judge looked directly at the board president and asked whether the home edition had been previously approved. The president hesitated, then admitted it had. Approved. In writing. By the HOA. The judge closed the file, shook his head, and let out a short laugh. Not loud. Not cruel. Just the kind of laugh that says, this should never have been brought to court. The judge dismissed the fine on the spot. No deliberation. No recess. He called it arbitrary, unsupported, and unenforceable. Then he warned the HOA that continuing this kind of enforcement could expose them to serious legal consequences. The gavel came down, and just like that, the $1,000 shadow vanished. But the real damage to the HOA? That didn't happen in court. The courtroom emptied fast after the ruling, But the fallout started immediately. The HOA board didn't look at me as they packed up their things. No confidence, no smugness, just stiff movements and forced professionalism. Their attorney left without a word. Outside, a few homeowners who'd come to watch quietly nodded at me, like they'd just seen something they'd always suspected but never thought they'd witness in public. Within a week, the tone from the HOA completely changed. The daily fines disappeared from my account. The violation notice vanished from the online portal. Then came the email, short, carefully worded, and painfully polite. It confirmed the fine had been removed in light of the court's findings. No apology. No explanation. Just damage control. But the judge's warning didn't stay confined to my case. Neighbors started talking. People who'd paid questionable fines in the past began requesting records. Others asked for copies of bylaws. Suddenly, the board that once ruled through intimidation was flooded with emails they couldn't ignore. The same president who'd bragged about teaching me a lesson stopped attending open meetings altogether. A month later, the HOA announced a review of enforcement procedures. Translation: panic. Committees were formed. Rules were rewritten. The board hired a new management company and quietly raised dues to cover legal costs, costs they never would have faced if they hadn't tried to find someone for sunlight. And the shadow still shows up every afternoon, right on schedule. The funny thing is, I never wanted a fight. I just refused to be bullied over something imaginary. And that's the real lesson here. HOAs rely on silence, not rules. The moment someone pushes back, with documents instead of fear, the whole system starts to crack. And as for that shadow, it's still there, free, legal, and undefeated.